A traditional legal trial demands physical evidence, sworn testimony, and a high burden of proof before a penalty is issued. A modern digital complaint portal requires nothing more than an internet connection. Instantly, a storefront can be flagged, investigated, and fined. Today, occupational licensing covers nearly 25% of the United States workforce. These oversight systems were constructed with a clear statutory mandate: protect consumer health and safety from genuine hazards. But the administrative mechanisms designed to enforce these rules have developed a specific structural vulnerability. They are being used by market actors to exert competitive pressure on their rivals. This practice is known as the weaponized complaint. Competitors, rival firms, or disgruntled former employees utilize regulatory intake channels to initiate bad faith investigations against their specific targets. The Noor-Pennington Doctrine typically protects the right to petition the government, but it contains a strict exception for sham petitioning. When a competitor files a series of anonymous, baseless complaints, they are abusing the administrative process solely to impose prohibitive costs on a rival. To see how this tactic functions, we have to examine reputation economics. This discipline measures the financial loss a firm suffers when trading partners, customers, suppliers, and banks change their behavior after a regulatory infraction is publicly exposed. For a small business, an active regulatory investigation inflicts immediate, asymmetric damage. Commercial bank financing is frozen. Prospective clients take their business elsewhere, and high-performing employees defect to protect their own professional standing. This financial destruction happens during the preliminary investigative phase. The business is penalized by the market long before regulators ever attempt to prove guilt in a formal hearing. In an information economy, coupling regulatory power with total anonymity creates a systemic friction. When the market reacts to the news of an investigation before any facts are proven, the unverified accusation becomes a potent market sanction, often ending a business before due process can even begin. State-sanctioned occupational licensing originated in the late 19th century under state police power. Early regulation applied strictly to high-risk, technically complex fields like medicine and dentistry. These early state boards operated as localized peer review panels. Because practitioners worked in close physical proximity, oversight relied on direct observation or sworn, notarized affidavits from identifiable members of the public or professional peers to maintain standards. By the mid-20th century, the administrative state expanded. Thousands of lower-risk, high-interaction occupations, like cosmetology and personal care, were brought under the jurisdiction of state licensing boards. To process this volume of licensees, regulatory agencies institutionalized written complaint procedures. By the early 2000s, boards began dropping the penalty of perjury requirement, transitioning from sworn physical affidavits to digital online portals. Regulators argued that dropping identity verification and accepting anonymous complaints was necessary to protect vulnerable whistleblowers and junior employees from professional retaliation. Removing identity verification shifted the system's incentive structure. By eliminating legal and social consequences for lying, regulators transformed the complaint system from a public safety shield into a competitive sword. We can map exactly how this weaponization plays out financially using empirical event studies in reputation economics. Researchers can track the precise moment the market prices a regulatory action into a firm's value. This graph charts the market value of public companies facing regulatory scrutiny over time. Look at the vertical node labeled Initial Allegation. The line drops an average of 1.69% the moment an allegation is announced. At this moment, no charges have been formally proven, yet the market penalizes the firm's value based entirely on the perceived risk. Trace the line further out to the final resolution node. When the actual legal outcome is determined months or years later, the line remains relatively flat. The market has already priced in the reputational damage up front. For a massive corporation, a temporary dip in equity is survivable. For a small, privately held vocational school or local clinic lacking substantial cash reserves, this early financial freeze is frequently fatal. Between 2021 and 2024, the Kentucky Board of Cosmetology provided a clear case study of this mechanism across the beauty industry. Established salons and schools filed repeated anonymous complaints against new market entrants, citing minor technical infractions. These unverified filings triggered unannounced, hostile inspections by regulators, resulting in immediate fines and business closures. Because the market reacts the moment an investigation begins, the final truth of the allegation becomes irrelevant. The target businesses were bankrupted by the administrative friction and legal costs of unverified accusations. The United States Constitution defines a state-issued professional license through a specific legal lens. Once issued, it represents a certificate of competency that carries a significant set of procedural protections. This property interest falls under the Due Process Clause. It means the state cannot revoke or restrict a license through disciplinary action without adhering to the constitutional principles of fairness, neutrality, and procedural regularity. To determine what administrative procedures are constitutionally required, courts apply the Matthews v. Eldridge balancing test. This framework weighs the individual's private interest in retaining their livelihood against the government's interest in protecting public safety. A fully anonymous complaint increases the risk of error. Because the respondent cannot investigate the context of the allegations or identify potential bias, they are stripped of their ability to effectively cross-examine an accuser at a hearing. This risk compounds when a licensing board, often composed of active market participants, acts as the investigator, gathering evidence, the prosecutor, levying the formal charges, and the judge ruling the outcome. Operating an open, anonymous complaint system without independent oversight fails the constitutional balancing test. It delegates state police power directly to private actors, allowing them to impose severe economic penalties without facing constitutional scrutiny. Highly functional, high-stakes regulatory bodies understand this vulnerability and actively structure their intake systems to prevent market sabotage. Major private accreditation agencies like the Higher Learning Commission and Sachs-Cock act as gatekeepers for federal funding. To protect institutions from unverified attacks, they strictly prohibit anonymous filings, mandating that all complaints be formally signed. Furthermore, these accreditors require complainants to provide documented proof that they have exhausted all internal grievance procedures at the institution before the Regulatory Commission will even open a case file. We see similar structural safeguards applied across centralized, non-U.S. jurisdictions. The United Kingdom utilizes arm's-length surrogate regulators. By separating standard setting from active market participation and enforcing strict identity verification, they ensure professional boards are not captured by self-interested practitioner cartels. Consider Singapore, widely recognized as a global standard for administrative efficiency and transparency. Their regulatory agencies deploy robust improper purpose filters to screen incoming reports. They utilize independent administrative tribunals to rapidly triage filings, identifying and dismissing retaliatory abuse before a formal investigation begins. The most efficient global regulators do not sacrifice due process for speed. They maintain rapid responses and preserve public safety, precisely because they require verified identities and separate the investigative staff from the adjudicators, actively neutralizing the threat of competitor sabotage. The structure of a regulatory system directly dictates the organizational culture of the market it oversees. Businesses adapt to the incentives they are given. Under open, anonymous regulatory systems, an adversarial complaint culture takes hold. Businesses secure their market share not by improving their own services, but by devoting resources to monitoring competitors and exploiting anonymous portals for rent-seeking and sabotage. When anonymous reporting is eliminated, organizations are forced into a continuous improvement culture, often referred to as Kaizen. Resources previously wasted on rent-seeking are redirected internally toward rigorous documentation, sanitation over compliance, and actual value creation for the consumer. Fostering this productive market requires a clear policy roadmap. State legislatures must enact statutory improper purpose filters, granting licensing boards the explicit authority to summarily dismiss bad faith, competitor-driven filings upon initial review. Operationally, state boards must eliminate purely anonymous public web portals. Intake mechanisms must transition to secure, identity-verified internal systems, requiring complainants to sign their allegations under penalty of perjury. Finally, regulators must be prohibited from issuing immediate punitive closures for minor, non-safety-related infractions. Instead, boards must provide a mandatory 30-day written correction pathway, allowing small businesses time to cure technical deficiencies. The statutory mandate of any occupational licensing board is to protect the health, safety, and welfare of the public. They can only fulfill that mandate when they close the administrative loopholes that allow their regulatory authority to be weaponized by the very market they were built to oversee.